Ladies and gentlemen, we're very privileged to have Maryna and Matt from Sectional Title Solutions here today to talk to us about the Consolidated Practice Directives. It's quite a mouthful, recently presented to the industry by the Community Schemes Ombud Services. And we've had a couple of questions and concerns raised by our clients, and there are just about every attorney out there in the sectional title industry commenting on it, and there were even comments regarding a potential prison and other fines that our trustees and scheme executives could face in if they don't comply. And we thought it best to have the experts in the industry to come and talk to us. And Maryna, just tell us a bit more about yourself, your role at Sectional Title Solutions.
Perfect. Yes, so I am the current group director specializing in governance, risk and compliance, but been with the group for quite some years as well. Also started off as a legal professional and obviously specializing in sectional title and sectional title education. Been involved with the TRACS, the MPO education platform that we do have. So yes, educating on this topic has been quite a passion.
Thank you. And Matt, yourself?
So I've also been with STS for quite a while. I also started off as a legal professional, but currently I perform the role of the origination and advisory manager, looking after all our clients that approach us for various solutions, walking them through the processes of passing the required resolutions and making sure that everything's valid and enforceable from our side. So also very involved in the education side of things, writing blogs and keeping an eye on the industry.
Thank you. I'd love to talk about TRACS a little bit later, just to reiterate the benefit to our clients on the TRACS platform that we also provide every one of our schemes throughout the country. But let's get back to the discussion on the Consolidated Practice Directives. I wonder if we can't just use CPD, maybe not, because that's the CPD points that you get from the PPRA. So let's talk about the directives, the new directives. Just to allay the fears out there, your first take, any suggestions, any advice that you can give us and our clients on the new directives?
Yeah, so I think everybody would know and understand, I think, where CSOS is coming from, because I think we all have that struggle wherein you would look for guidance on, you would read the act and you're like, okay, how do we practically apply this in our environments? Then CSOS actually introduced a few directives, but they were a few, they were duplications. Some of them actually contributing what the other one was saying. So the benefit and my personal take on it is, first of all, to simplify and to have it all consolidated, have it all in one framework. So it's not I need a practice directives on the payment of the CSOS levies, how it works, what bank account details I need to use. On the other side, what is the undesirable rules? On the other side, what are the actual prayers that I can take to CSOS and the applications that they have. It's all in one document. So yes, benefit from that point of view because you can only reference one document.
Yes.
Personally, I've experienced, even if you went on their website and you just try to get the latest version of this directive, it was quite a mission to get. So yes, it does have its benefit. We have one singular document that you can refer to now. But yes, it does have its pros and it does have its cons. Not massive differences as to what has been recorded in these previous directives. Matt will actually talk a bit later on the actual things that are new, but the crux of it is just providing more clarity on a lot of things. So that is definitely a benefit, I believe, for our community schemes, for the managing agents as well. But it does come with like you have said in your intro as well, it does come with a bit more stricter enforcement from a CSOS environment. So again, it's actually nothing new because this has been recorded in the Act. It's been recorded in the legislation, but also now just in the practice directives. So it's just CSOS taking a bit more active role in enforcing compliance around it.
Thank you. So it's not anything new. It's just a bit more consolidated. They're structured. They give us a bit more this is where to find the information in one place. That's basically why it means consolidated. Am I right, Matt?
100%. And I think that's the main benefit you get from this. You don't need to go looking for the practice directive that applies here. It's all in a single available spot.
Okay. So, like Maryna said, what's changed? Were there any changes in the new directives?
So there have been a couple of sort of clarifications. I wouldn't say massive changes per se. I think the main thing is stricter compliance and enforcement. The directive makes it clear on the registration, annual returns, levy payments, proper records are no longer negotiable. It's a must-have. They've clarified and they've consolidated their undesirable rules, things that most schemes really need to pay attention to. What should be in their rules, what shouldn't be in their rules. And then, tighter governance and administrative obligations. Schemes must be correctly registered on CSOS Connect. And I think personally, we've seen a few schemes that just out of, ignorance or complacency just haven't gone that route. And I think that could start to hurt them now, particularly in light of this. And then there's sort of the slightly contentious matter, which is the data privacy. CSOS dives into the effect of PAPIA and PIA on data privacy. What can they disclose to, or what can that body corporate disclose? What can't it disclose? And there is a little bit of contradiction there between case law that's out there, as well as the obligations in terms of the Act, in terms of data sharing with members. And I think what we're likely going to see there is some amendments and some changes to bring it in line with and to clarify for the industry as to what's expected. And then, clear procedures and for fines and penalties. Arbitrary fines are out. Schemes must have ensured that written warnings are done. Really just touching up and clarifying what we already expected, but filling in the gaps.
Matt, everything that you've just said, we really, as managing agents, ensure that compliance for our clients. Now, we've got a set of rules for bodies corporate and full title schemes that have been processed through the CSOS before, with any schedules pertaining to fines, a process, to mediate, between role players, maybe trustees, ourselves, and owners, and sometimes even the occupants of the units, to try and avoid the matter being referred to CSOS. We really try and assist wherever we can, and we've got those rules in place already. Our schemes are all registered with the CSOS. We provide we submit the annual returns diligently every year. We pay the quarterly CSOS levies over to them, so our schemes are compliant. So should our clients be worried? I don't think so, unless they're non-compliant. But again, we can assist them with any discrepancies there.
No, yeah, sorry.
Yeah, I think Arthur specifically on whether the client should be concerned or not. The concern comes in if you're non-compliant.
Yes.
The concern is if your managing agent have not been in communication with CSOS, have not registered the rules, where the rules have not been compliant, if you haven't even looked at or touched PAPIA and that regulations around it within your community scheme, where you haven't reviewed your rules in quite a while. I think not actually knowing the exact stats, but if you just look at the handful of schemes that have actually done the correct thing, registered, got that rules approved, there's a big gap still, and I think that is what they're trying to address here, is they are trying to take quite a stricter approach to those schemes that have just simply ignored the whole CSOS process and what they're trying to achieve.
Absolutely. So compliance. And I can wholeheartedly say our schemes that we manage are compliant. If there are rule changes, we've got a set of rules that we can submit to the CSOS. We don't have to reinvent the wheel either. As I mentioned before, we've got all the necessary information, and our schemes are generally compliant. So if there are areas that we can improve on, let's focus on those areas. But really, our scheme executives shouldn't be too concerned about is the threat of prison. That really there are role players in the industry that mention the word, and that's caused a lot of anxiety with some of our scheme execs. But really, it's about compliance, and if your scheme is compliant, then there's no concern or need to be worried about. Am I right, Matt?
100%. So I think the primary principle here is being proactive.
Yes.
You've already mentioned that your schemes are up to date and things like that. But really, what should happen in the kind of scope and purpose of this new consolidated CSOS practice directives is go back, do an audit of the rules, do an audit of your documents, make sure that you are compliant. Tighten up on your administrative compliance in terms of CSOS, things like that, which by the sounds of it already happening.
Yes.
It was already expected in the past. It was already part of the day-to-day management of schemes. It's not changed.
Yes.
The problem now is that it looks that CSOS is going to be clamping down on it. We've spoken about penalties, we've spoken about jail time. So rather than worrying about that, let's take the proactive approach and make sure that we're fully compliant.
Absolutely.
And that's where the focus of the managing agents, because of their role that they play, should be.
Absolutely. Thank you so much. Can we touch on tracks just for a brief moment? I know that's not really what we wanted to discuss today, but I'm passionate about tracks. Like you mentioned as well, we were involved with the tracks process. Can you just give us a tidbit on the tracks platform and the idea behind it?
I would really love that. Thank you for the opportunity.
Sure.
Yes. So Tracks has been quite a big passion for our company as well. I think if we look at the reality within our industry is unit owners buying into your sectional title schemes and not actually being educated. Half of them don't even realize, how heavily legislative their property is that they are staying in. Often they don't even know what they can get involved in, what their rights are, what they can and cannot get involved in. So what Tracks really helps. So Tracks actually has a e-learning course that is freely available, 5 languages that you can get on the website. And it's basically your 101 for owning a sectional title property. It helps you on what do I need to prepare in meetings? Do I actually need to attend AGMs, SGMs? If I go, what can I participate in? Or what is the value of my participation? Because often people, they just ignore attending those meetings because they don't really see the purpose around it. It also helps them to be educated as to where their levy contributions go. What is the impact if I do not pay my levies, for example? Then we actually have, we've published a book as well. It's an electronic book as well as the hard copy. There it's a guide. We call it a guide because it really helps. So it's aimed at your unit owners. The first chapter, your second chapter is focused on your trustees, just providing them with a bit more guidance, and then your managing agents as well. Because again, everybody needs to work together to make it a success in the end. And everybody needs to be educated as well. I mean, there are so many case law, and a lot of times it is not simplified. I'm an attorney myself, and sometimes we even need to read the legislations and the regulations 3-4 times to make sure we understand it. For any layman or who doesn't even specialize in law, it looks like rocket science, and to actually see how it applies in your environment, that's what Tracks do. Tracks helps to educate, and they actually provide free education as well, because often people are reluctant to take on education if they need to pay for it. Because, why am I going to be educated on a property that I'm already paying an arm and a leg for, and I need to pay for education to understand this property that I've invested in? Whereas this is freely available, so meaning any and all audiences can actually participate.
I'm very passionate about the Tracks product as well. So Matt, every single one of our schemes, and we manage about 500 schemes already throughout the country, from Bella Bella to Blobergstrand, from Margate to Potchefstroom. We manage all over the country, and every one of our schemes got their own website. And on every single one of those websites, you've got a link to the Tracks platform. Every single owner, every single trustee in one of our schemes, it can access the Tracks platform, which is phenomenal. So all the information is right there at the fingertips or at a click of a button. So I'm very passionate about the Tracks platform as well, but it's easily accessible, it's easily available and free. So thank you again, Maryna and Matt. Thanks for your time, giving us a bit more. I think more comfort is the word that I'm looking for in terms of the consolidated practice directives. It's about compliance. Ultimately, our schemes are compliant already, very sure of that. And if there are any shortfalls, that's easily we can easily correct it. But be it as it may, I do think we shouldn't, our scheme shouldn't be too concerned. But thank you again for allaying those fears and giving us your time. Thank you.
Thanks so much.
Pleasure.